Principled Labor Law, U.S. Labor Law Through a Latin American Method is my book with Professor Sergio Gamonal. If you're aware of debates in labor and employment law, you probably know about concerns that labor law and employment law can no longer provide effective rules for the 21st century workplace. The law is said to be outdated and ossified. To some extent, this is true, but not entirely. That's because labor and employment law, like all other law, has guiding principles that can help courts and administrative agencies interpret rules and fill gaps. Latin American courts and agencies readily elicit a handful of principles, including the protective principle and the rule of in dubio pro operario, if in doubt, rule in favor of the weaker party, to decide cases where the black letter provides insufficient guidance. Hence, many contemporary debates in labor law, such as whether an Uber driver is an employee or an independent contractor, or whether a franchisor like McDonald's is a joint employer, can have clear answers under the Latin American system of principles. In this manner, principled labor law argues that Latin America has something to contribute to labor law generally. It articulates 4 core principles used by Latin American jurists to decide so-called hard cases: protection, non-waiver, primacy of reality or fact, and continuity. The book then argues that these principles exist in U.S. labor law. Yes, they do exist. They can be found in the statutory purposes of the laws, in their texts, and in collective bargaining agreements. The book assertions might surprise some U.S. labor lawyers, given that U.S. Labor jurisprudence has become increasingly conservative and neoliberal. We argue that such jurisprudence can change. In fact, we further argue, also basing ourselves in Latin American perspective, that the U.S. Constitution has a labor protective article, and that is the 13th Amendment, which protects individuals against slavery and involuntary servitude, and gives Congress the authority to legislate in order to make working relationships and employment relationships freer. This was the view of the radical Republicans who wrote the 13th Amendment in the 19th century, and it is a view that can prevail again today with the right social movement behind it. In all, principled labor law offers a simple, time-tested way to look at labor law and rebuild it in the 21st century. We invite you to read the book and put it into practice.